We begin with a precedent-setting ruling from Canada's top court upholding the federal government's jurisdiction to put a price on pollution. Eric Sorensen now with the details and fallout.
It is a landmark ruling on the division of federal and provincial powers. The Supreme Court of Canada has ruled that Ottawa's carbon tax is constitutional. The law was passed by the Trudeau government in 2018, whereby it can impose a carbon pricing system or a carbon tax. It's up to the provinces to do so, but should they not, or should they not meet a minimum national standard, then Ottawa can step in to backstop that and make sure that it happens. Now, Conservative provincial governments in Alberta, Saskatchewan, and in Ontario had appealed that to their appeal courts, believing that the law infringes on their jurisdiction. But the majority of the justices at the Supreme Court, 6 of the 9 justices, ruled that the law is constitutional. Chief Justice Wagner, writing for the majority, wrote that the Parliament has jurisdiction to enact this law as a matter of national concern under the Peace, Order and Good Government Clause of the Constitution. He went on to say that addressing climate change requires collective national and international action, and that the harmful effects of greenhouse gases by their very nature are not confined to provincial borders or any borders. So 2 justices disagreed entirely, 1 disagreed in part. Essentially, they do not accept that Parliament has the authority to pass the law and ought not to override the constitutional division of powers between the federal and provincial governments. But the majority have given the final word on this, on the federal powers in the case of carbon taxing or carbon pricing, and that the federal law is constitutional. Eric Sorensen, Global News, Toronto.